For pronouncement of judgment, item 44.
The bill dismissed.
I'm so deeply obliged.
Item number 18, we have filed an affidavit today. Could it be called for on the records 20?
Detail and concept of the respondent is submitted the day of file. Affidavit in counter to the IA. Today only. Is this matter after a week?
Valuation.
May I please? I beg to mention my lord, item 28, my the consent of the other side, my lord, for 2 weeks, my lord, eligible granted.
May I please?
Item number 28, 2 weeks adjourned.
May I please? Lordship, I beg to mention item number 34, Lordship. The senior standing counsel, Mr. H. out of station, Lordship.
Adjourn.
Lordship.
Please, my lord. My lord. In item number 32, my lord had asked me to give suggestion. The suggestions have been filed as an additional affidavit. So my lords may kindly call for record.
When?
Yesterday, my lord.
Yesterday, then a concept of the
Petitioner in person.
petitioner in person has submitted that he has filed an additional affidavit. Office to place the same on record and list this matter after 2 weeks.
Deeply obliged, my lord.
May I please, Lordship? With the consent of other parties, I beg to mention item number 35, Lordship. 35, Lordship.
5.
Yes, Lordship. Lordship, this may be kindly adjourned for 1 week, Lordship.
Adjourn.
Need please, lordship. Lordship, I beg to mention item number 26. I have instructions not to press this matter.
Learned concept with the petitioner on instructions has submitted that appellant that he does not want to press this writ appeal dismissed as in not pressed.
Obliged.
IA still disposed of. IA is there. IA to.
IA is also consequently the IA is also disposed of. Yes.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 27. CGC counsel, Mr. S.K. Methi, sir, is out of session.
27.
27.
Adjourn.
Date may be fixed, lordship.
Whatever date you want.
Obliged.
May I please, your lordship? I beg to mention item number 41, my lord. With
41.
consent of the opposite party, I pray for an adjournment.
May I please, your lordship? I am for respondent, by the respondent, lordship. Kindly fix the date, lordship, on 7th of March.
Adjourn for 7th of March.
May I please, Lordship? I beg to mention item number 45, Lordship.
45, yeah.
Yes, this matter may be kindly adjourned for 1 week, Lordship. Senior counsel got some personal difficulty.
You need adjournment.
Adjournment, Lordship.
Adjourn.
Obliged.
May I please, your lordship? My lord, I beg to mention item number 40, my lord. The hearing matter, my lord, will be taken up on next week, my lord.
Adjourn.
Lord, and I have another prayer, my lord, for listing of an item, my lord, of 2021 pending read appeal, my lord. Next week and date, my lord.
Next week, Thursday, Friday.
Oblige, my lord.
May it please your lordship. Mother, in some difficulty, I'm praying for listing of a matter for motion day after tomorrow. Tomorrow, actually, first half I'll not be there. So day after tomorrow, if lordship kindly accommodates me.
After tomorrow, it may be there may be some difficulty. Have it on Monday or Tuesday?
By that time, my lord, what I see through is that the bank is insisting that we vacate the premises. And we say that we have, the sale is not complete and there's a person,
Securitization matter?
securitization partly, but now the sale has not been
We are
effective.
Going to entertain, you get it listed on Friday or any other day. We are not going to. Your wish.
I understand. I clearly understand.
Understand then it's better.
Right.
Next week.
Daily list for orders item 1 to 4.
Item number 1, I'm preparing the petition. And the petition item number 1 in PIL. This honorable court had queried that the vending zone have to be provided to the unauthorized vendors. And also
Last
some
occasion-
surveyors may.
On last occasion, we granted time to run a standing concept for GMDA to submit a town vending committee plan. In respect of this, what happened to that?
Lordship, we require 3 weeks time, Lordship, to place it on record, Lordship.
How much time?
3 weeks, Lordship.
Okay.
Just say this.
Then concept
3 weeks.
so and so appearing for the GMDA seeks 3 weeks more time to place on record the proposed plan for systematic placing of vendors in thickly populated area. Just after 3 weeks.
Item number 5.
Lordship, in this case, to finalize the pension, 10 days time more is required, Lordship. As per application of, from the petition, applicant, Lordship, fixation of grade pay is wrongly calculated as 13,300. Actually, it should be 11,500. So we need 10 more days time to complete.
So and so place for inducted. In the 2 weeks time to do the needful.
Deeply obliged.
Just after 2 weeks.
Item 6.
Lordship, today we have filed affidavit, reply and affidavit, Lordship.
Today you are fine.
Yes, Lordship.
Consent for the petitioner has submitted that affidavit on behalf of the petitioner in response to the reply of the respondent is filed today. Office to place the same on record. List of 3 weeks.
Obliged, Lordship.
Item number 7.
Please, my lord, the respondent number 8, my lord, impleted respondent has filed one affidavit, which has stated in para 2 that there is no budgetary provision, and so fund cannot be released to the petitioner. So this issue, my lord, perhaps, my lord, an affidavit has to be filed by the petitioner.
You want to file affidavit in
Short affidavit, my lord. And this issue was, my lord, has to be dealt with, my lord, because admittedly, this amount has not been paid for last so many years.
No, but why are we agreed with this order?
My lord?
The
My lord,
repetition has been allowed.
no, my lord, we are on a context that there is no budgetary provision. That has been stated by the impleted respondent for the first time, my lord. This issue was never before the honorable single judge.
Claim verified. इसमें contractor ने appeal किया. I don't know. ये contractor मतलब petitioner. इसलिए appeal.
So they,
But you have to pay the amount.
now in paragraph 2 of the respondent 8 affidavit, they said that, my lord, if I can read, my lord, that in connection with the issue raised in the instant read appeal. Earlier, this statement was not there. pertaining to non-payment of admitted work contract bill amount against the execution of contract work so and so, where the non-availability of fund is attributed to non-creation of budgetary provisions by the state government, PWD Assam. I beg to humbly state the deputy secretary appeared by the letter that. So communication was made, but the budgetary provision has not been made. Some, in my humble opinion, some direction may be required. My lord.
Direction to whom?
To the authority, my lord.
The direction is already there. In view of the submission, learned counsel for the writ petition is disposed of and the admission is itself with the direction to the respondent number 2 and 3. To examine the claim of the within a period of 45 days. And the respondent authority will process the claim of the in accordance with law. That is, the direction is already there. 2 and 3 are the principal secretary and the additional chief engineer.
Now they, my lord, the Hill Area Department, they,
How you are aggrieved by this order?
my lord, I'll file a short affidavit, my lord. I'll bring on record the document that supplementary demands are made till now, my lord. But
At least you, at least satisfy us. How you are aggrieved by this order and you have filed this, preferred this writ appeal against this order. How you are aggrieved? This is your petition.
yes, yes, my lord.
And in your petition, the court has, the learned single judge has given a direction to the respondent number 2 and 3 to verify your claim and then to make payment.
Now, while doing for verification, my lord, they have expressed that there cannot be any verification done because the fund has not been there.
File contempt for that reason. If they have any excuse, the learned single judge will
My lord,
exempt them.
one
Or
thing, my lord.
otherwise, they pass appropriate order.
Let me file one affidavit, my lord. I'll bring on record.
What, sir?
But there is one issue, my lord, which has evolved now from there. My lord. Short time may be given, my lord.
You just satisfy us how you are aggrieved by this order. You just. please
My lord,
just
actually,
satisfy
my lord, I am going through
you are
the,
aggrieved by this.
my lord, with all respect, I am going through the affidavit respondent aid. And I found
Respondent
that,
date of affidavit in this writ appeal.
yes, yes.
Writ appeal, forget about it. How you are aggrieved by the order passed by the learned single judge, you satisfy us.
My lord, lordship, will kindly give me some time, my lord, on that.
Mr. Barua, do you know who is standing between your client and the disbursal of the amount?
Yes,
You know who is standing? You are standing in between.
my lord. My lord, I beg, my lord, kindly give me some. I'll file the reply, my lord. With that, I'll, my lord, argue one.
A writ petition
Are
which has
you-
been,
Please let us know how you are aggrieved by this
My lord, I
order.
am agree, my lord, because that writ petition was disposed of on the submission of the NC Hills, my lord.
So
That is-
it's a very good case
But-
for contempt. Since they have admitted on their admission or their submission, the writ petition is disposed of, what more you require now?
My lord, one issue has come up, my lord. Let me, my lord, file on affidavit, my lord, then your lordship will go to. For a
After
short,
4 weeks, Chale.
Item number 8.
2 weeks, my lord, I'll file.
4 weeks.
Obliged,
Take your own time, Aram.
Obliged.
You please find out how you are aggrieved by this.
my lord.
And then satisfy us.
Lordship may peruse the office note dated 21 to 2024, my lord.
My lord, service report is awaited, my lord, and in fact, we have also taken instruction that the Dusty has also been served and we are required to file an affidavit, my lord.
You are filing
My lord, for the Dusty service, my lord.
on behalf of the respondent number.
No, no, my lord, for the petitioner, my lord. The Dusty service has been effected as per the order of this honorable court, my lord. And to that effect, we will file an affidavit. My lord.
Okay. Then it consent for the appellant, petitioner has
Petitioner.
submitted that the notice upon the respondent number 2
My lord.
has duly been served and for in that relation, he is going to file an affidavit. Therefore, he placed some time. Time paid for is granted list after 10 days.
My,
Lordship, SCWMD might be reflected in the cause list, SCWMD. Though there is an order of this honorable court dated 4/12/2023 to reflect our name, but
The list on so and so, and showing name of so and so.
deeply obliged, my lord.
Item number 9.
Service not complete on respondent number 7. Who is appearing for the, you are appearing?
Lordship, I'm appealing for KAC, Lordship.
Respondent number
Respondent number 4 and 6, Lordship.
4 and 6.
Yes, Lordship, extra copies also not been served to us. Therefore, we do not take the instruction.
As per the office report, service of notice upon the respondent number 7 is not complete. It's the matter number 11, 9. Service of respondent number 7 is not complete. Counsel for the petitioner is required to take steps for serving the notices upon the respondent number immediately filed within a period of 1 week on furnishing the same letter. Fresh notice to issue to the respondent number 7 returnable after 4 weeks. Then it, counsel for the petitioner is also required to furnish the furnish the requisite documents to the counsel for the respondents. The other respondents.
Item number 10.
Then my lord, I am for the appellants, state appellants. My lord, I have perused the office note, my lord. Service by usual steps are complete. However, my lord, Dusty was directed to be taken, my lord. At that regard, my lord, we have to take instruction. This matter will listen after 1 week, my lord. The Dusty has been effected or not, my lord, by the office.
The request of land counsel to the appellant list after 2 weeks.
My lords. Obliged.
Item number 11.
Please tell us. This appeal has been prepared by the State of Assam Lordship. As per the office note dated Lordship 21/2/2024, neither AD card nor unserved notice has been received till date in respect of respondent number 1.
When the fresh notices.
I think also we should wait for some time because the unserved notice has not been received.
Return of notices of the respondent number 1 for 2 more weeks.
Must be necessary.
Item 12.
May it please the Lordship. Lordship, this is the matter relating to recovery of remuneration received by reason of the respondent overstaying in employment.
Last time.
Yes, Your
you
Lordship.
got some
Lordship,
time to-
I'm conscious that Your Lordship views that equities are with the respondents. Lordship may give me just few minutes. I will just state my case.
Most welcome.
Oblige, Your Lordship. Lordship, more than state my case, the predicament that faces the appellant as a public sector company. Lordship, the respondent joined in 1990. At the time of joining, he submitted 4 documents, which were evidence of his date of birth. I will not bother you with all 4 of them, but there are 2 that are important because there are declarations contained therein. Lordship, may kindly see page 89. Lordship has page 89.
Yeah.
This is the biodata that he had to fill and submit, which he did in 1990. The date of birth is 1/3/56. Lordship has 1B. Lordship, then his declaration is at page 99. This is the correct date of birth. Declaration is at page 99. I so and so, last paragraph of Lordship, it's a standard declaration. I so and so solemnly declare that the information given are true and to the best of my knowledge, and that I shall be liable to appropriate disciplinary action under the company's standing order if subsequently found I had given false declaration. This is, and he signs it at page 100. This is the one document. The next document is at page 106. Similar declaration. It's a pro forma that he has to file again. And Lordship, date of birth is 107, number 7, serial number 7. Again, this is correct date of birth, 1956. And he makes, and there's again a declaration, last paragraph. I certify that the foregoing information is correct, complete, to the best of my knowledge and belief. I'm not aware of any circumstances which might impair my fitness or employment under government. So, Lordship, my submission is that he knew what his age was. I'm not even showing you, Lordship, the other 2 documents, which are school living certificates. So there are 4 documents which he submitted and he knew. So the question then arises is, was there not a duty on him to disclose at the time when he realized that he had retired, that he had retired? And given the fact that we asked information from him and he certified these information and that he had a duty to speak, would his silence not amount to speech? And would it not be concealment of a fact known to be?
Why you have referred to this declaration? Page
Lordship,
99.
sorry, Lordship?
Page 99, you have referred to this declaration.
Lordship, because he has declared it to be true, so he knew.
Yes, it is true.
Lordship, then concealment of a fact which he knew to be true is also fraud, your Lordship.
No, there is no concealment.
No, Lordship, he has, Lordship,
He has given the exact,
no, I am not, Lordship, I don't have a fraud with this document.
just a minute.
Sorry, your
Please
Lordship.
listen. He has given the correct date of birth in his
Yes,
declaration.
your Lordship.
And he has simply gave a declaration that if any such information is found to be incorrect, false declaration, you can take disciplinary action appropriate.
Yes, your Lordship.
Action.
Yes, your Lordship.
So that part is over.
Yes, your
He
Lordship.
has not furnished any wrong information.
Yes, your Lordship.
That's all. Now, the question is, he was supposed to inform you that I am going to retire on so and so date,
Yes, your
and
Lordship.
he has not
Yes,
disclosed.
2016, he should have, on the basis of his own knowledge, should have retired. So question arises, did he or did he not have a duty to disclose? And if he's failed to disclose, knowing that he should have retired,
What action you have proposed against?
Lordship, at the moment, Lordship, equities are, but Lordship, as a public sector, Lordship, please understand my predicament. Can I condone this? Can I condone this and then set a precedent that it's okay? And Lordship,
It was
or
expected
do we
from
at least
you.
try? Because Lordship,
It was expected on behalf of this public undertaking to at least conduct an inquiry that who is the person
Lordship, we
who is
can,
responsible for change of the date of birth in the service records. And you have simply said, since the date of, this date of birth of yours is manipulated or some interpolation in the service record, therefore it is deemed that it is you who have done it.
Lordship, Supreme Court says if you're a sole beneficiary of a fraud, it must be presumed that you were party to
Equally,
it.
the Supreme Court has also said
Yes, your Lordship.
that. in
Lordship,
cases-
I'm aware of the equities. Lordship, only thing is, our predicament is that we actually did conduct departmental inquiry. He came to court and said, sorry, you can't because I've retired, which is why we stepped back and withdrew.
On the other day, my lords have pointed out, why you not initiated any criminal proceedings against that person?
Lordship, the respondent is retired. We were only,
So, I mean,
we are only interested in the money, your Lordship.
you are-
It's public money that we wanted to recover, not prosecute him criminally, your Lordship.
Benevolence against that person that since he has retired, we are not going to initiate any criminal proceedings and you expect that we should not.
Lordship, I leave it to you. But Lordship, only, this must not operate as a precedent.
Can't be. Because in the facts and
Lordship,
circumstances of this
yes.
case only. Can't be. Some will dictate all.
Oblige, your Lordship.
Learned single judge also said that he will not be entitled to benefit of promotion
Yes, yes.
during that period. So that's a balanced order.
Yes. Lordship, should I give you the citations of the judgment? Oblige, your Lordship.
Item 13 to 17.
No, in 13, my lord, they have complied, my lord. They have withdrawn the order yesterday.
In view of the fact that the respondents have already recalled the order, which is apparently in violation of the order passed by this court and has furnished an unconditional apology in reply. We are not inclined to pursue further this contempt petition. The same is therefore closed.
The rest of the matters can come up for a hearing, my lord, on its turn.
The other item.
Only date will be fixed for hearing. Only date will be fixed for hearing.
Which day?
Maybe next week.
It's a matter of how everybody is ready for next week and on that day, everybody is.
Process of tender, it has to be.
End of March, my lord. No, it will be too late, lordship.
21st of March.
Obliged.
14, 15, and other students.
Item 19.
May it please lordships. Lordships, the IA has been filed seeking confirmation of delay of 23 days in filing the connected writ appeal, your lordships. On the last occasion, notice was
Service
issued by
not
the
complete on.
on the respondent number 3 and 10, your lordships, yes. Perhaps service may be awaited.
Anybody is appearing on behalf.
I'm for the respondent numbers 1 to 4 and 5. We have no objection, Lordship.
It's only a,
What about 3 and 10?
lordship, they're the private respondents. We have named, made them a party by name, your lordships.
Then.
We'll have to perhaps
Notices are
wait,
required to be served upon.
lordships.
Okay, as per the office report, the service of notice upon the respondent number 3 and 10 is not complete. Full stop. Learned counsel for the applicant may file the requisites in the office within a period of 1 week for serving the notice, for service of notice upon the respondent number 3 and 10. On furnishing the same, that notice be issued to the respondent number 3 and 10.
Lordships, we've already taken the requisite steps. This is on the returnable date. We've already taken the steps, fresh steps.
Fresh step.
Lordship, may I be permitted to take dusty service?
Be permitted to take this thing.
Lordship, deeply obliged.
Item 20.
We make confirmation 101 days, service not complete on respondent number 2.
Lordship, my lord, the service report may be awaited, steps have been taken, lordship. My lord, already one set of,
6, 12.
my lord, government is challenged in another appeal, lordship, that is already admitted, lordship.
That's right, but let the formalities be completed.
Lordship,
Await return of notice of unserved respondent for 2 more weeks.
lordship. Obliged, lordship.
Item 21.
Lordship, the respondent number 1 has been served, Lordship. We have filed an affidavit to the returned, Lordship.
169 days.
Page number 5, Lordship.
169 days. 3 years exemption. Compassionate.
Likhna. Notice upon the respondent number 1 of the IA is duly served, none has appeal put an appearance on behalf of the respondent number 1. Having heard the learned counsel for the applicant and after going through the contents of the IA, we deem it appropriate to condone the delay of 169 days in filing the present appeal. In filing the connected appeal, hence the IA number so and so is allowed, and the delay of 169 days is condoned. Office may register the, office is directed to register the connected appeal and list it for admission after 2 weeks.
Obliged, your Lordship.
Item 22.
22, my lord, this is IA preferred by the NHI DCL, my lords. My lord, subsequent to an order passed by the honorable court, my lord, there was a direction to conduct a valuation exercise and submit a report. What had happened, my lords? It was not pointed out during the, when the judgment was given, my lord. The office of the arbitrator was not present, my lord. It was abolished by the state. And apart from that, my lord, the CPWD was directed to conduct a valuation exercise and the income tax department. Income tax department said they don't have the required professionals or they are not within the domain. However, CPWD, my lords, they conducted an exercise, and my lords, now Assam government has, central government has appointed the arbitrator, my lords. So my lord, now we have submitted a report, right.
So what remains now in this?
So my lord, now my lords, we, my IA has 2 parts, my lords. Other, my lords, since the report exercise of valuation, the measurement has been carried out and has been submitted to the arbitrator, my lords, we may be allowed to proceed with the work, my lords. It has been stalled for last April 2023, my lords.
Where are the earlier orders?
My lords, it's annexed to my IA, my lords. First, initially, my lord,
At which page?
my lords, I am being agreed by the order dated, my lords. Page 39, my lords. Annexure F. 39, my lords. Operative part,
That's 39.
39. It's a rate appeal, my lord, 375.
So now, what modification you are seeking?
Modification, my lords, that part since my lord, CPW has corrected that, my lord, CPW has now done the exercise, my lords.
Of valuation.
So yes, my lord, not valuation, the exercise, my lord, that measurement has been taken. So they will submit the valuation report to the learned arbitrator who has been appointed.
So the court has directed this national. Nah, that's all. This CPWD to prepare for presentation of the valuation officer.
My lords.
It is hereby that a copy of the order shall be presented to the valuation officer in the central, provided by the within 2 days, wherever authority shall appoint a suitable date. They
have done it. They have done it, my lord. But a predicament we faced, my lord, the learned arbitrator office was not there. Now, my lord, subsequently, central government has appointed, my lord. My lord, I have given those documents yesterday. We have applied. We have approached the arbitrator that please grant us leave to go on with the construction, my lord. So that part is gone, my lord. Since, my lord, my humble praise, my lord, since the evaluation exercise of measurement has been taken, my lord, consequent evaluation report will be submitted. So, my lord, my lord will permit us to carry on with the construction, my lord.
Court has already clarified it that the ad interim order passed by the arbitrator shall stand vacated after valuation report is prepared and presented in the arbitration proceedings. That is.
Yes, my lord.
more than clear.
This was, my lord, this happened, my lord, after filing of this IA, my lord. Only recently central government appointed. At the time of filing this IA, my lord, arbitrator office was absent, my
So
lord.
what clarification now you are?
My lord, that we can go on with the construction, my lord.
But who is preventing you?
My lord, that may be expressed. That may be, my lord,
There is no
observed.
need of that, sir. The court has clarified it already. The ad interim stay order dated 19/4 passed by the arbitrator shall stand vacated after the valuation report is prepared and presented in the arbitration proceedings.
My lord.
So you are the valuation report is prepared.
My lord, only measurement has been done. Valuation will be submitted to the arbitrator, my lord.
Till the valuation is to be done,
My lord.
how can you do that?
No, no, my contention is that since everything is now in books, my lord. So it will be, my lord, it will be prepared and submitted, my lord. So since measurement has been taken, my lord.
Valuation report is prepared.
No, only exercise, measurement has been taken.
Who is going to this prepare the valuation report?
Well, CPW will prepare, my lord. Since
CPWD
yes.
have only conducted the measurement
Yes, my lord.
and not prepared.
No,
any
no,
valuation
no, my
report.
lord.
Till then, we can't modify this order, sir.
My lord, my eye has two parts, my lord. My lord, considering that the arbitrator has been appointed, measurement has been taken on book, my lord. So there's nothing remains, and on the measurement book, it will submitted, my lord, valuation will be prepared, my lord. Pending that, my lord, we may be allowed to go on construction, my lord. Carry on construction. My lord, it's stalled from last April 2023, my lord.
Yeah, that's right.
And that about, my lord, when that order was passed, my lord, it was not pointed out the
Who is
arbitrator
appearing
office.
for the CPWD?
CPWD lordship, Mr. H. Gupta is appearing, Mr. Harish Gupta is appearing for CPWD, but he is suffering from fever today, lordship. He is unwell, so I.
At least they should prepare the CPW should prepare a valuation report. Once the measurement is there, prepare a valuation report and give it to them or to present it before the arbitrator.
I'll inform lordship because I have been informed just now, right now.
And because of this installation, my lord, this is like because of this point it is stalled, my lord. This has led to installation of the project and other points also.
That's fine.
My lord.
They will take care of that.
I'm for the opposite party number 1, 2, 3, and 4, my lord. I'm the landowner, my lord.
So if the measurements are already there,
But my lord,
they'll prepare the valuation report in due course of time.
but my lord, if my lord.
Yeah, ultimately, the land has to be acquired.
Yes, my lord.
Only question is that the valuation report is not there. And that's why only the arbitrator has stayed the proceedings.
Yes.
Now, if the measurements are there,
My lord, unless and until the valuation report is not been submitted, my lord. My lord, the landowner will be in difficulty because this is in regard to, my lord, inadequate compensation, my lord. And my lord, more importantly, my lord, the valuation report has to be submitted before the arbitrator and should be in the presence of the competent authority, my lord. That respond number 7 and 8, which has been by the last order, it is included, my lord. They were not present in the court today, my lord. So may I pray, my lord, this any order may be passed in presence of the Kavianang Autonomous Council, my lord.
And it is not that they have been paid, my lord. The difference of only 20 lakhs. 60 lakhs have been paid to them. Now there is a claim which goes to the tune of 80 lakhs, my lord. They have been substantially paid.
Mr. So and so,
Lordship, copy has not been served to our court. IA copy is not.
Mr. So and so, for Mr. Harish, who is appearing?
H. Gupta, lord.
Harish Gupta, appearing for the CPWD, has submitted that due to some personal difficulty, Mr. Harish Gupta is not able to attend the court today. He pays a short adjournment, full stop. Time paid for is granted, however, by the next date of hearing, the counsel for the CPWD may inform this court that, inform this court that by what time the CPWD will prepare the valuation report in respect of the property of the private respondents. Number
My lord, 1 to 4.
1 to 4 and submit before the arbitrator. Submit and submit in the arbitration proceedings. Full stop. In the meantime, the copy of the IAB supplied to the counsel for the respondent number 1 to 7 and 8. Respondent number 7 and 8. List this matter on 19th of March.
Can it be earlier, my lord? Monsoons have set in, my lord. We have suffered delay for a long time.
12th March.
Deeply obliged, my lord.
You inform Mr.
Lordship,
Gupta.
lordship. Oblige.
Item 23.
Service not complete on respondent number 329, 324. No, sorry. 324.
Lordship. I am for the respondent.
Private respondent.
You are the respondent?
State respondent.
We are appealing for the state respondent. The other private is 3 and 4, my lord. That service was not completed, my lord. And the ASTI also affidavit was not filed. By the petition.
As per the office report, notice upon the respondent number 3 and 4 has not been served. Full stop. 24 back. Await return of notice for 3 more weeks. await return of notice of respondent number 3 and 4 for 3 more weeks.
Item 24.
It's. इनका नाम नहीं दिया इनका नाम नहीं दिया
This restoration application after 2 weeks while reflecting the name of the applicant in the cause list.
applicants count.
And also
Applicant consent in the cause, applicant as count. Applicants,
petitioner in partner,
applicants consent and the consent for the state.
health department also.
GA Assam is already there.
Their health department is also party lordship.
Consent
SC
of
health.
the- consent of the health department
Deep levels.
in the cause list.
Item 25.
May it pleases your lordship. Lordship, this is a contempt application along with an IA for condonation of delay. Lordship, on the
Surface of this not complete on respondent number 126.
lordship, lordship,
And
we will be allowed to take fresh steps.
2020.
This is what contempt appeal.
Lordship,
Appeal
The applicant has been
convicted.
convicted.
lordship. This is against the contempt,
So what's the order in the contempt petition?
lordship contempt petition, they had dismissed it, saying that there was no prima facie case.
Oh,
So-
it's not maintained.
The appeal is not maintainable against the dismissal.
Lordship, another date may be given. Lordship, the arguing counsel in this matter is Mr. R.B. Fukan. He's not present today. Lordship, he had to leave the court premises due to some personal difficulty in the second half.
Okay, as per the official board notice upon the respondent number, non-applicant number 1 to 6 have not been served. Let await return of notice of respondent number 1 to 6 for 2 more weeks. However, on the next date, the counsel for the applicant may satisfy this court about the maintainability of this contempt appeal.
Lordship, oblige your honor.
For admission, item 29.
May please your lordship. My lord, it was a motion day. My writ petition was dismissed on the ground, on the motion day itself, that similar disposition was preferred by the same society without considering the fact that the earlier writ petition was being represented by a person who claimed to be the chairman of the society, which he was not. Your lordship, please to see at page 103, the impugned order.
Society का जो chairman उसके बाद यार दूसरी बार ये लोग आया
earlier, this petition was filed by unauthorized
Unauthorized
person. And they said writ petition was dismissed on what ground? On
That
merit.
similar writ petition was filed
No, no.
by the same society.
Their writ petition was dismissed on merits,
That writ petition is pending.
still pending.
It is pending.
Then file an application in that application that this person is not authorized and I am authorized. Substitute me as a petitioner.
Now, that's what we do, but this writ petition has been dismissed with a cost of rupees 50,000. And both the writ petitions were prior was to make it hearing on the both the writ petition.
Mr. Das, all good things come at a cost. Why are you opposing it?
And ultimately, a direction is issued to the Guwahati Bar Association Welfare Fund to deposit the money. What's wrong in that? It's your
Well,
bar.
Well,
It's your bar.
dismissal, earlier writ petition ought
Okay,
to have been
okay,
dismissed.
Okay, Mr. Datta. So you will deposit, huh? Mr. Das, you deposit 25,000 in personal capacity, will exempt this. Ultimately, the bar, why the bar should suffer?
My only objection is that the earlier writ petition ought to have been dismissed. Both the writ petitions should have been heard together. But it was not. One gentleman from the bar sprang up and said that I was a caveator in the earlier writ petition. Therefore,
It was his duty to inform the court about the facts.
yes. And therefore, on that very day, it was difficult on my part. Your Lordship please to see at page 10 of the memo of appeal, the additional fact which has come to the knowledge. Page 10 of the memo of appeal.
So, yeah, 25,000 is somewhat cost in on a higher side. You propose what cost you are supposed to, your petitioner is supposed to deposit.
Good. Yeah. Dismissal. Because. What is it?
Yes,
It is difficult for me to bear the cost.
then why don't you accept the cost imposed by the court?
No, writ petition has been dismissed.
That's right, we don't find any illegality in that. Two petitioners can't find the two separate petitions for the same cause of action. One petitioner. One petitioner cannot file
That is
two
correct.
petitions for
That is correct. But
same cause of action.
But that is correct. But a cooperative society is being represented either by the,
It's purely a disputed question of fact that whether you are the authorized person or he was the authorized person.
no, your Lordship please to see at page, Kiman, 68,
68. Yes.
68. He had long been removed in the month of September itself.
Just for 1 day to take the. The other
Let's
person
just-
वो chairman नहीं था. Was he the chairman at that point of time when he?
No.
He was
No,
not-
no,
Neither chairman nor secretary.
no, secretary. Nothing of the sort.
Just along with the record of the WPC number 6854 of 2023. After 10 days. Well, like to see the record of that case.
Yes. Because he has shown in the affidavit that is on 21st of November, posing himself as the chairman.
We'll go
But-
through that record and then we'll pass
Yes. Your lordship is fixing up a date
10 days, after 10 days.
after 10 days.
Okay.
Item 30.
Lordship, here in this case, Lordship, on last occasion, Lordship directed me to take instruction whether that person is still, and that post is still available or not. That post is available, Lordship, as per my instruction. Lordship.
Lordship, he will join their lordship, but his seniority may be protected, lordship.
Seniority, that is in as per the prevailing law, hoga. How can we grant such type of
Because
how can we issue such type of direction that seniority and whatever other service benefits will govern by the as per the service rules?
But lordship, as per the unwillingness certificate enclosed by the authorities, it was said that if he forgo his promotion for lifetime, then he will not be transferred.
It's not.
It is in the record.
That question has not come out, Lordship. That
Again, you are-
that question has
again,
not
you are
come
on
out as on that,
merits.
Lordship.
Lordship,
Again, you are on merits.
I am not on, let's say, I'll have to be, I'll have to join their lordship. I'll join. I'm ready to join, but I'm just,
Join earlier or-
I'm paying for protecting the promotion seniority, lordship.
Seniority that will be governed by the whatever the rules are applicable. We can't if you if they fix your seniority at a particular date or whatever it may be, and if you agree, you can challenge that.
That's it. But my contention is that because my unwillingness was rejected by the authorities after 3 years. They were sitting over a matter for 3 years and saying that if you forgo your promotion, MSCP increment, etc., then you will not be promoted.
That's not right on their part.
Yes,
to-
lordship. That's why, lordship, I have approached the honorable court.
No.
And lordship, direct,
Pursuant to
lordship.
the direction given by this court. On 23/2024, learned counsel preparing for the central government has informed that the post where the petitioner was sent on promotion is still available in Roorkee, Uttarakhand. Full stop. Taking into consideration the Uttarakhand, full stop. Having heard the learned counsel for the petitioner and after going through the impugned order dated 15/2/2023 passed by the Central Guwahati Central Administrative Tribunal Guwahati bench. And the other material based on report by the learned counsel for the petitioner. We are of the view that no, that the impugned order is not required to be interfered with as the petition, as per, interfered with because as per the service conditions of the petitioner, if his application for foregoing promotion is rejected, then the petitioner is required to join at the place where he is posted on, at the promotional, required to join at promotional post. Full stop. Hence, no interference is called for. Writ petition dismissed.
Not obliged.
Yes, I consequently the IO is also, number so and so is disposed of.
Obliged.
Item 31.
Lordship, may I pay for a observation that at least 1 month time should be given so that he can, his daughter is lordship.
Whatever it may be,
No, no.
you agree.
Lordship.
The provision is already there.
Yes, no.
Joining time is also always there.
Obliged, lordship.
May I please your lordship? Lordship, the appellant first applied for the
post on compassionate ground on 9/2/2017. It is lordship on in page number 49. Serial number 8. Where petition appellant's proposal was rejected due to want of vacant post. Thereafter, lordship, the appellant approached the Honorable High Court, and the Honorable High Court directly responded to reconsider the matter of the appellant. The judgment is page number 53, lordship.
Page number
53.
But the interim judgment here is on page 69.
Where the Honorable High Court
yes, 52.
52, yes, lordship, the
Page number
52.
52. Yes. On
There-
considering the present, it is seen that the deputy director is not made a party. However, considering whether the deputy director party is not, registry is directed to the writ petition is disposed of. What was the direction? Kya tha? What was the direction? Council as well as the consideration of Office Member of Assam. Clause 15 of the, it appears that the DLC is due to lack of vacancies. They say without considering the other vacancies, clause 15 of the OM provides sufficient vacancies not available. Particular office applicant, so and so, it is open for the administrative upon government to provide an early appointment compassionate accordingly the matter is remanded back. Yes, then what happened after remand?
Lordship, when next time applied for the post, then his his application was rejected, saying that his application that the appellant applied for the post after lapse of 1 year. That is on page number 63.
63.
63.
Yes.
63. Serial number 8, lordship. Last column.
Abul Kalam, the DLC dated so and so discussed the proposal and could not consider the proposal. He has not submitted his application within 1 year. So when this is the government servant expired on which day?
On 12/2/2016.
12,
12/2/2016.
2016. And you applied in pursuant of that
9/2/2017. First time applied.
9/2/2017.
17.
Okay, that application was rejected, then you preferred a writ petition.
No, lordship, thereafter applied for the another 2 times. That is 31/5/2017 and 39/2021.
ये कौन सा ऑर्डर क्लियर हो क्या है? कोई मेंशन नहीं है कुछ, तो कोई मेंशन नहीं है कौन सा ऑर्डर क्लियर, कुछ नहीं है वो. This appeal is against which order? हाँ तो कैसे इसमें 2-3 अलग अलग ऑर्डर थे, मुझे तो लग रहा था ये ऑर्डर बीच में.
Lordship order dated 29/3/2017. 23.
Where you
Six-
mentioned in the
60.
appeal, where you mentioned in this writ appeal that you are agreed by this order.
पहले जो अप्लाई किया था उसमें वो माइनर पहले इसको जो अप्लाई किया था 31 उस समय वो माइनर था उस समय ये था 1 साल के अंदर देना एक साल में कितना दे माइनर से अप्लाई नहीं कर बाद में सेकेंड टाइम जो अप्लाई किया तो उसके उसका मेजोरिटी की 3 साल 1 साल में मेजोरिटी भी है वही रेवेन्यू
The learned single judge has consulted you on the ground that when you moved the first application in February and thereafter in May in 2017, at that time you were minor.
Yes, sir.
And you attained the majority on 13/12/2017, but you filed an application for compassionate appointment after 3 years. So why should we consider this application? What's wrong in that? You should have filed an application within 1 year of attaining majority.
Lordship, the respondent did not inform the appellant also
What?
whether his past application was considered or not.
Your date of birth is known to you, sir. Either the respondents will inform you. You are aware of your date of birth. Then
Lordship, the appellant also was going through mental trauma. His father died.
then he was going through mental trauma and is suffering from some mental problem.
His mother was also
Then
died.
please
Lordship.
oblige the government and don't apply for this government job. If you are having some mental problem, how can you discharge the duties as a government employee?
No, Lordship.
A mental problem, we are not supposed to ask them to appoint a person who is suffering from a mental problem.
No, Lordship, he's not a patient of mental problem. He was going through mental trauma, Lordship. And
Huh?
mental trauma. Lordship,
Mental trauma, so it can again occur anytime when he is in the government job. So that would be not beneficial for all of us. Not in the public interest. Anything else?
anything else, Lordship, the respondent may be directed to reconsider the matter.
Again.
Lordship, again.
Again,
His Lordship. He's the
for what reason?
Lordship, he is the only member remain of his family. His father died, his mother also died.
scheme is no longer there.
Your father died on in the year 2017.
16, Lordship, 12 to 2016.
And it's almost 8 years have passed now. What type of hardship you are facing? If you are able to survive for 8 years without there being any government job, certainly you can survive further.
एक मुद्दा यहाँ पे ये 2018 में 17 और 12 में तो 1/4/2017 से ये स्कीम डिसकंटिन्यू हो गया कंपेशनर और उसके बदले में 1/4 में कंपेशनर फैमिली पेंशन वही तो इसका कन्फ्लिक्टिंग जजमेंट कोई कहता है कि नहीं दिन एप्लीकेशन आए उस दिन जो लॉ है जजमेंट में लिखा है नहीं दिन डेथ तो अच्छा मेरा भी जजमेंट तो उस दिन से जजमेंट का जो उसके होता है सुप्रीम कोर्ट का बात वो जब वो लेना उसी को निकाल नहीं उनका कोई सुप्रीम कोर्ट का जजमेंट है नहीं 10 साल बाद भी कंसिडर जिस दिन एप्लीकेशन देगा इस दिन जो
Having heard the learned counsel, yes.
My lord, at the time of my lordship, may kindly see the rejection order, page 54, my lord. 54.
You simply said after 1 year.
No, my lord, the lower age limit cannot be, my lord, relaxed. Although, my lord, there is a provision for relaxation of upper age. That is also one of the ground. Serial number 4, my lord, page 54.
Yes.
Point number 16, the government office memorandum so and so, dated so and so. The upper age limit could be relaxed wherever found to be necessary as per the existing government policy. The lower age limit shall, however, in no case be relaxed below 18 years. Age eligibility shall be determined with reference to the date of appointment and not the date of application, my lord. He was admittedly, my lord, at the time of my application, he was minor, my lord. Was not 18.
Is there any provision under this, that existing compassionate appointment scheme? That any person who attained majority can move an application after attaining the majority in so and so time?
No, my lord. No, there is no such provision.
There is a gap here.
And in fact, second application, he moved, my lord, after 3 years of attaining the majority.
Not second,
Having
that
heard
was,
the learned
that was
counsel
third time.
advice, we are of the view that matter requires consideration, hence admit no need to issue notices, parties are already represented. List for hearing in the month of August 2024.
Item 33.
My lord, the petitioner before this honorable court for seeking relief against the illegal art cutting in the Jorabat area, 9th mile and 10th mile. In this regard, the petitioner approached before the forest department as well as.
There were earlier petitions filed on same subject.
That is the difference.
Artificial flood, flash flood, all these, so many PLs have been filed.
Different revenue circle. That was of different revenue circle.
This pertains to, my lord, the Jorabat area.
This is of different area. That is the same subject but different area.
No, after the deluge in 2016, which happened in Jorabat only, there were barrage of PLs in this high court.
Okay, sir.
What has happened to the same thing is same issue.
There was a provision.
Not that.
My lord, post it tomorrow or day after, my lord.
You should get it confirmed if on the very same subject, if the PAL
Yes, my lord.
were filed and entertained or disposed of, whatever it may be, then we'll club, if those are pending, then we can club it along with that, and if those are disposed of, we can dispose it of in terms of that or Nikhil and a concept of the respondent state. Place for and granted time to verify whether in relation to the issue raised in this writ petition, any writ petition was filed earlier before this court. And if so filed, what is the status of the same? List after 2 weeks.
Obvious, my lord.
Item 36.
Sure.
May I please, your lordship?
Lordship, affidavit in opposition has been filed yesterday. Maybe 2 weeks I'm granted for a reply.
Petitioner pays for a granted time to file affidavit in opposition to the reply filed on behalf of the state. Time period for granted sponsor less up to 4 weeks. Reply to the company. Affidavit in reply.
Publish.
Item 37.
May appeal, Lordship. Lordship, here is a case, my lord, despite my lord, the action given by this honorable court, my lord, no affidavit in file, but subject matter is that, my lord. But to reduce the burden of the, my lord, lower court of PT cases up to 3 years punishment, my lord. A notification was issued by the GOP on 22/10/2022. Now, out of which that notification, my lord, that all the cases which pertain to up to 3 years punishment, that has to be dropped. But my lord, it shows that despite of my lord, that notification has been issued, the results are not much coming in, my lord, the
What is
project
the
that
notification that all the cases wherein less than 3 years of punishment is.
up to 3 years, my lord, yes.
Then
That, my lord, what happened that
those
we
cases
have
are to
applied, my lord?
those cases are to be dropped.
Yes, my lord. So that is the notifications part, my lord, that says so. Now, question that despite after issuance of that notification, my lord, the all law courts have taken certain initiative to support dropping the cases of up to 3 years, my lord. But Lordship, as on today, my lord, RTI application that we have preferred and we have found information that each and every court, my lord, the 100 and 1,000 cases are still pending. Now the poor litigants are running from court here to there. Some instance also happened to my cases also, where my lord, despite that falls within the category of that my lord notification, it has not been dropped. Now, apart from Lordship, that notification also comes some special my lord laws also. Like suppose my lord food safety standard 2006, where suppose punishment up to 6 months or 1 year, my lord. That has to be dealt with in the light of that notification. That has also not been considered. Ultimately, there is no any conformity, my lord. There is no any uniformity of dealing with the such cases. The orders are coming in a different way, in different flavor, my lord. My lord, in this regard, my lord, last occasion while this matter was taken of this honorable court, 24/1/2024, a direction was given to the respondent 1 and 2 to take individual to the notification also, my lord, submit report to that effect, my lord.
Which notification?
My lord, 22/10/2022.
We have received the instruction, but before that, my lord, I'd like to take your lordship to page 23, my lord.
23, my lord.
For a moment, my lord.
23.
23, my lord. It's not that we are not following the procedure or that has not been complied with, my lord. Their criminal case comes around to 3.5, my lord, introduction part. There are more than 4.5 lakhs of case pending in various subordinate courts in Assam, out of which criminal case alone comes to more than 3.5 lakhs. Below line, my lord, in the introduction part, the pendency as on 36/2022 is 3,66,342 criminal cases. And it's not a joke, 3 lakhs criminal cases. And it's not that the case has not been withdrawn. And for a time being, page 26, my lord. As the procedure laid down, my lord, 9, clause number 9, my lord.
Yes.
Public prosecutor, additional public prosecutor, assistant public prosecutor shall move the withdrawal petition before the respective court on the date fixed of the cases, my lord. When the date of the case has been fixed, if it comes that it is below the 3 years, only that time that can be withdrawn, my lord. So it is following the procedure as laid down in the SOP. It's not that we are sitting idle or nothing has been done, my lord.
My lord,
Yes, lordship is also ever in the case. 4 lakhs, 3 lakhs criminal case pending, my lord.
my lord,
Today, if any date is fixed, next, my lord, it takes around 3 months at least to get a date. My lord, it will take some time. It is not that you are sitting idle or nothing has been done, my lord. It's
well, let them file their affidavit, my lord.
and the PIL is required to the strict
We'll do one
compliance of the SOP, my lord.
We'll do one thing.
My lord,
As a special measure,
my lord.
we propose to appoint Mr. Chamaria
My lord.
as a judicial magistrate in one court. No, and then you decide those cases
My lord.
any number of umpteen number of cases are there, you decide those
My lord,
cases within a period of time limit, whatever be.
Lordship, I make the position very much clear. My lord, kindly see, even I can place certain orders, my lord, of the lower court. Unnecessary, my lord, that has been, my lord, delayed, my lord.
If there is no application.
There must
the
be.
Part of the public prosecutor. How they can proceed? sir?
Exactly, my lord.
There
That's
are
why I'm
so many
saying, my
things,
lord, let the government will proceed because that the duty casts upon the, my lord, public prosecutor to, my
How
lord.
about if you are appearing in the subordinate courts also,
Yes, my lord.
how much cases, case load is there, sir? In
My-
one court?
My
How
lord, there,
many cases are
my
there?
lord, there are thousands cases. There is no doubt to that.
This is-
My
Do you expect the magistrate will?
My lord,
work
in a-
in
in a-
no, my lord,
manner?
what I'm saying, my lord.
In a
My lord,
case
kindly see, my
related to
lord.
section 138 of the NI Act, next date, at least 3 months, my lord. He
Kindly-
also cannot deny, my lord.
My lord,
Very early.
my lord,
Nothing to do, my lord. There are lots of pending cases.
Very early in comparison to the other states. In Uttar Pradesh, a complaint or whatever the case under section NI Act, after its presentation, 3 years after date is there for dealing with that.
yes, my lord. But that is the object, my lord. My lord, can you see what is the basic object of this notification? The notification says to reduce the burden of the lower courts cases.
File
My
the
lord.
reply.
The reply is required, my lord.
Mr. Chamaria, you are also referring to domestic violence cases.
My lord,
When you
no,
take
my
up
lord,
this-
there, my lord, classifications are there, which case doesn't fall within the category, my lord. Kindly see, my lord, the categories of cases which has been exempted.
Yes, 28.
My lord, certain categories of cases has been exempted. What I'm saying, my lord, if suppose there is a uniform pattern or certain directions come from the honorable court, that they have to take expedite measures to.
Uniform pattern in the judicial matters.
My lord,
SOP has not been challenged, my
my
lord.
lord,
Administrative
SOP,
functions, sir.
lordship, what I'm saying, my lord.
इसमें डिले हो रहा है क्यों डिले हो रहा है क्या ये कारण वैलिड है नहीं है उसको बिना देखे सिलेबस
My lord, until unless certain directions come from the honorable, my lord, this will go, my lord, continue, my lord, I don't know how much time it will take, my lord.
Mr. Chamaria, there is no instance of delay in any case unnecessarily. Can you give us one instance?
Yes, my lord, I
which-
can give, even
Give-
in my
give-
cases,
give-
my lord, I can
yes,
give, my lord.
Yes. That means you are interested, you are
No, my lord,
doing it
my lord, my
personally.
case is already dropped long back, my lord. Afterward, my lord, but question is that because this situation we have faced or other also faced, my lord. As on today, I do not have any such kind of case which because your question is that, my lord, if certain procedure be followed, my lord, if my lord, that public prosecutor either or the court, my lord.
How can in a judicial proceedings a uniform order can be passed?
My lord, kindly see that,
It's not expected. It's
my
not
lord,
a-
1 year has elapsed, my lord. Till that, my lord, RTS says that the thousands cases are pending, my lord.
You do one thing,
My lord,
you suggest what order should be passed by the, or what direction should be given by the High Court. You suggest us.
my lord, give some time, lord, the affidavit is also necessary, my lord.
All cases. You prepare a procedure.
My lord, I will
according to
try my
which
level best, my lord.
All
If some-
cases will be disposed of.
We'll try, my lord.
And in concept of the petitioner pays for and granted time to give his suggestion. The petitioner present in person is as prayed for and granted time to. Furnish suggestions on his behalf which may enable the courts, particularly the subordinate courts, and particularly the trial courts, presided by the judicial magistrates, to get this matters decided in which, where the punishment is up to 3 years in a time-bound manner. How much time?
My lord, 2 weeks time, my lord, I will try, my lord.
3 weeks time.
My lord, in between, if suppose the lordship pass them direction to file affidavit.
Give your
My-
suggestions,
I will-
ask them, if those suggestions are worthy enough,
My-
ask them.
So item 32.
एक 32 आइटम नंबर है, इसके अंदर जो गिव दिया था वही इसी में दे दे। एक साथ लिस्ट अलग लिस्ट अलग
Item 38.
My lord, this matter pertain to, my lord, the victim compensation scheme. My lord, which is, my lord, the part of 357A, my lord. My lord, so far, my lord, the information that we have gathered, the various cases up from 2015, my lord, despite that award has been, my lord, that my lord, judicial order has been pronounced, the person has not, my lord, got their benefit, my lord, because of the, my lord, fund that has not been earned by the government, my lord.
Yes.
Lordship, I'm appearing on behalf of the respondent number 3. Lordship, we are only the implementing agency. And as and when the government disburses money to us, we have, in fact, I filed my affidavit today. Unfortunately, it is not on record.
What about the
Government, Lordship.
why you are not releasing the fund?
My lord, department, my lord, it's an affair. I am representing the home department, but.
Why you are not releasing the
No,
funds?
Lordship, for that, if that is, I do not have the complete information regarding the funds, Lordship. But if there is a proposal, Lordship, there is no blockage from the finance department.
Have you filed reply?
No, Lordship, I'll just seek for some time.
Find your response.
Yes, Lordship.
And you are appearing for
Home department.
home department is also a party.
Yes, Lordship, they are the
File
ones,
your
I'll
response.
take inspection.
File your response.
Lordship.
Okay. Reply on behalf of the respondent number 3. The counter to the writ petition on behalf of the affidavit in opposition on behalf of the respondent number 3 is already filed. Office is directed to place the same along with this file. Learned counsel appearing for the respondent number 1 and 2 praised for and granted to file their affidavit in opposition. List after. Yes, how much time?
3 weeks.
4 weeks.
It's a serious matter. You please
Lordship.
complete your instructions. 4 weeks.
May I prefer date if lordship is listed.
4 weeks after 4 weeks.
Both matter may be, my lord, the same date, both matter can be given same date, my lord, if possible.
That we have already fixed another matter.
If possible.
Item 39.
Wait, please, Your Lordship. My lord, I seek for a little accommodation in item number 39. My lord, let this matter be passed over for the day, adjourned for the day. In 42, I will do the hearing, my lord.
Construction of new medical college.
Yes, building, my lord. There are some anomalies and all in construction of this building.
That is construction is going on.
Almost complete.
Almost complete.
Yes, my lord. And without the proper procedure, my lord, after the tender has been opened and my lord, money has been siphoned off by showing them as escalation cost. I'll come to that. Your lordship may fix it as per your lordship's convenient on it.
The construction is already over and they.
No, my lord, we are, my lord.
What is the objection?
No, my lord, if there are financial anomalies, that construction, that part will always taken in a care of, my lord. Your lordship will dispose of it in the next day. Let me make my submission on a date convenient to your lordship.
8 weeks. List after 8 weeks, the request of land council for the petitioner.
Supplementary, item 46.
Let's see, in this case, challenge the e-auction notice. It is 6/12/2024, annexure 11. As per auction sale notice dated, sale will be held tomorrow. That is 29/2/24.
Page,
Page, let's see, 155.
what?
155.
155.
Yes. This is the type copy. Date of auction is written in page 156. That is 29/2/24.
Auction notice issued against date. You can proceed against guarantor. But if notice is served on that person, the auction sale will be invalid. Whether today or after, whatever.
My lord, they can raise this grievance before the debt recovery present. Yes.
This person
It
was
is- it
expired?
is 22, your lordship. 22, this is 2022.
Have you raised this objection before this debt recovery tribunal?
Yes. I
What
have
happened
raised
to
it, objection in the learned tribunal, but the petitioner informed me telephonically is in the year 2022. At the time of filing, date was not available with him. When the
With
learned,
whom?
I'm
Date was not available with whom?
with the borrower.
Borrower is the Suchakra,
No,
this
my lord.
Motors. He preferred this IA in 2023.
Yes.
And who was the person, the deceased person, name of the deceased person?
Jivan Barua.
Huh?
Viren Barua.
Biren Barua is the guarantor.
Yes.
This
I'm-
Suchakra Motors is the proprietor.
Yes.
So this proprietor is alive.
Yes, property is alive. As on today, he will. Annexure.
And property also belongs to the proprietor. Property also belongs to the proprietor, is not to the guarantor.
Then how does it matter?
My lord, I may be allowed to discuss. In annexure 1 of the petitions, this is the sanction letter. It is a sanction letter dated 5/5/2017, page 119 of my petitions. In the said letter, name of the Biren Barua was written as a guarantor.
Yes.
I have a challenge auction sale notice before the tribunal in 2023. In my petition, I have specifically mentioned prior to issue of notice, guarantor has expired. So bank ought to have issued notice to the legal heir or to the guarantor. If they return back, in that case, it establishes that person is no more there.
The property.
And I have
Also
Property proposed to be auctioned belongs to whom?
belongs to the petitioner number 2 of the petition.
Petitioner number 2 or the proprietor?
Proprietor as well as petitioner number 2.
Number 2. Okay, then they can very well proceed further, sir. No problem at all.
Your Lordship, what happened when I challenge auction,
Hey, you raised this objection before the appellate tribunal. In the day-
let me give it a chance. Just
Yes.
my submission is that as soon as SARFAESI action is taken by the bank, I immediately approached to the bank for settlement of my loan. In November 23, bank subsequently when filed written objection, in the written objection simply write, you pay all the dues as early as possible. But what I stated in my letter, November 23, they have not considered. Simply say all amount to be paid at an early date as per demand notice. Then I approached to the tribunal. Tribunal fixed the matter on 19 January 2024 for hearing. Auction sale was fixed on 20 January 24. Planet Tribunal, without hearing opposite party, just one day before of the auction sale, simply fixed the matter on 25th January, without allowing the interim prayer for stay. On the date of, on 25th, when I appeared before the tribunal, tribunal simply said matter is dismissed. But he has not narrated on what point it is dismissed. From 25th January up to 16th February, I wait for copy, but he have not allowed. Ultimately, I requested the concerned register to give me a certified copy, and same has been obtained, and which the certified copy I filed before your honor. It is on record. It is obtained on, I think, 19 February. I'm just. 154. 154. The fifth 149 is the judgment and order, and the date of obtain is more particularly. Kindly see page 154, bottom.
Yes.
That is 19 February 2024. I obtained the certified copy. On that particular day, I gone through the order. Immediately after 2 days, I approached the bank.
You applied only on 7/2/2024.
From the date of order, neither the consul official allow me to go through the records, what order passed. Under such circumstances, I approached the registry. Registry asked me to wait
It's a
for.
good ground for condonation of delay.
My lord.
Before the tribunal, it's a good ground for condonation of delay before the tribunal.
Actually,
You can seek exemption
actually-
for so many days.
Actually, my intention is to settle the loan account. That is why I approached on
Your
21st
intention
February
is to settle
24.
the loan account and approach the court, not the, approach the bank and not.
Your
this
lordship,
court.
I have approached on 21st February. As on today, bank hasn't responded to me. Only get a chance to make the payment so that I make the payment.
How much money and when are you going to pay?
As per their notice, it is 60 lakhs odd.
Pay day after tomorrow?
In my letter, I seek 6 month time in my letter.
Six months time.
It is up to the bank how much time will be allowed, but
No,
as on,
we are giving you time.
all right.
Day after tomorrow, 60 lakhs rupees, all the dues you pay.
My lord,
Income.
it is not possible for the
We'll
petitioner.
pass an order day after tomorrow that don't confirm the same.
My lord, tomorrow is not possible because
Huh?
my petitioner is not in a position to pay the due. That is why
Then.
in any
go-
times, your lordship
then
may
go
allow.
Challenge this order.
Your lordship
of the
may-
Tribunal in the that particular tribunal in the appellate tribunal.
Only give him a chance to say,
No.
make a payment.
We are nobody to give a chance. It is for the bank to give them chance. We are not. We are not owing any money. You are not owing any money to us. We have not given you the loan, so we can. take them.
My prayer is to that any order, your honor, my lordship may pass. Just give me opportunity to settle the matter.
Your opportunity by day after tomorrow. You pay whole amount. This is the last opportunity.
My lord, actually, as on today, it is a fact. But he is not, he cannot position by tomorrow.
Anything else?
The minimum time is needed as lordship. As on today, his son is at hospital.
Sorry, sir.
A reasonable time, as your lordship. did.
This writ petition is filed by the petitioner. Filed on behalf of the petitioners. Essentially being agreed with the e-auction notice dated 22nd of date of the e-auction notice.
6/2/2024.
6/2/24.
6/2/24. Whereby the bank has proposed to auction a residential house, or what is it? Bank has proposed to auction, क्या है ये? What is the property is?
Land and building.
Land and building.
Land and
Proposed to auction the land and building mortgaged with it by the petitioner in lieu of a loan of rupees. How much loan was of rupees?
Loan is, your Lordship, earlier 35 lakhs, subsequently the enhanced up to 50 lakhs.
35 lakhs, full stop. The petitioner has not paid the monthly installments in time. And therefore, the loan account of the petitioner was declared as non-performing assets. And proceedings under under the provisions of the Securitization Act of 2002 has been initiated against him. Those proceedings, a notice under section 13(4) of the SFAC Act 2002 was issued by the respondent bank, and the same has been challenged by the petitioner before the Debt Recovery Tribunal, Guwahati, by moving an application under section 17 of the SFAC Act. However, they said OA that the said application was dismissed by the tribunal on 25/1/2024. And thereafter, this auction notice dated 6/2/2024 is issued by the bank. Stop. Having heard the learned counsel for the petitioner for quite some time, we are of the view that the proceedings initiated against the borrower in the matter of, we are of the view that in the matter of initiation of the proceedings against the borrower by a financial institution under the Securitization Act are ordinarily not entertainable by this court while exercising by High Court by exercising powers while exercising powers of ordinary jurisdiction under Article 226 of the Constitution of India in view of the various pronouncements of the Honorable Supreme Court and the proper course for the aggrieved party is to approach the authorities mentioned under the Securitization Act. In the present case, the petitioner has already approached the Debt Recovery Tribunal, and the Debt Recovery Tribunal, by moving an application under section 17 of the Act of 2002, and the same has already been dismissed, the remedy available to the petitioner is to approach the appellate tribunal under section 18 of the Act of 2002. Hence, we are not inclined to interfere in this petition. The same is therefore dismissed.
Your Lordship, my presence may be marked with you.
Except nodding what you have done.
Your Lordship.
For hearing item 42 and 43.
May please, your Lordship. Before my respected senior starts, my lord, I may be, my senior is on legs, my lord, court number 3. So let my senior starts, my lord, we will give reply, my lord. Some other day, my lord.
Well, a public road is in question out here, construction. That's why your lordship has fixed it early for final disposal.
Pass over for the day. Monday, Passover for the day, it will come out, Monday or Tuesday.
Tuesday.
Well, just, I'll take the date from the court master, my lord. I'll see my diary.
Sure. I apply.